Good morning, everyone, and welcome to the September 2023 edition of the Morning Blend. I'm Alison DiFlorio, and I'm so honored and pleased to kick off our fourth year, yes, 4 years of doing the Morning Blend with my co-host and partner here, Lori Halber Armstrong. Hi, Lori.
Hi, how are you? It's so nice to see everybody this morning.
Hard to believe, Lori, that we've been doing this for 4 years.
I know. I can't. When we were just doing the math, I was like, it can't be that long. But
I
I
know.
do think that those COVID years are sort of distorted our time space continuum.
I think they have. For those of you that have joined us before, welcome back. And for those of you that are joining for the first time, welcome. We developed this 4 years ago because we felt there was a need in the community, our community of business leaders and HR leaders, to bring to you the latest and greatest legal updates to help you stay on top of things and stay compliant and plan, and also the hot trends in human resources so that you can hear and we'll share some of the best practices that we are seeing in the marketplace with the clients that we're working with. We do have somewhat of a packed agenda today. Whenever we're planning these sessions, we never really know what's going to happen. And in planning this one, there are quite a few legal updates that I think you'll find really, really interesting. And we'll be talking about some of the return to office updates that we have heard. As always, this session is being recorded, so your phones will be on mute, but your questions are really important to us. So if you do have questions, please feel free to use the question button, and Lori and I will do our best to check that throughout or certainly address them before the end of the session. And if it's anything that we don't have time to address, our contact info is always at the back of the presentation, which will be sent out to you. Link to the presentation will be sent out afterwards. And you can feel free to reach out to either one of us at any time. So that said, we want to go ahead and move forward. Some of you may know our stories, but we'll give you just a quick update for those of you who are joining for the first time. Alison DiFlorio, co-founder, managing partner of Exude Human Capital. We are a Philadelphia-based consulting firm with practice areas in human resources, diversity, equity, inclusion, belongingness, and leadership development. And we support over 200 clients, both in the for-profit and not-for-profit space, in all three of those practice areas. So what I hope to share with you today are some of the trends that we're hearing, particularly as it relates to returning to the office and the current climate of changing culture. And Lori?
Well, good morning. For those of you that I've not met yet, as Alison knows, I have been practicing exclusively in the space of workplace law for I guess I have to add a year or two, 26 or 27 years, something like that now, which means I represent management side companies on a variety of topics, including discrimination, wage and hour, but also traditional labor, which we'll be spending a little bit of time talking about today. In my spare time, I corrupt young legal minds at Temple Law School, where I serve as an adjunct professor. And I am also a mediator with the EEOC in their ADR, Alternative Dispute Resolution Program. So I do want folks to know that although I'm with sometimes people go, ooh, Fox, big firm, I actually represent a variety of clients from, sort of large folks that you would know to smaller businesses and quite a few nonprofits at this point. And when Alison and I were getting ready for this morning, we were talking about the inordinate amount of information coming out of the National Labor Relations Board. And we said that we really need to make a point to let you all know that if you are a smaller business or a nonprofit, it's sort of the opposite of what you might think. You might think this won't apply to you, but you are actually the target right now for a lot of the activity that's going on. So when we get to that, we'll be giving you some information and some tips. And lastly, Fox, my firm, is a full service firm. So we have attorneys that can help with pretty much, setting up your business, with tax issues, with trust and estates, family law, you name it. I have somebody who can help you. So, and I'm delighted to continue this partnership with Exude and work with Alison and her team on doing this program with you all on our, I don't know if we do it quarterly or bi-monthly or whatever, but it's so much fun. And I think I'm hoping that our folks that join us find it worthwhile.
Great. Thank you, Lori. Thanks for your partnership. I think it is quarterly, but we'll figure that out. So as always, we've got piping hot. You've probably heard as of August, there's new Form I-9. We'll talk a little bit about that and some of the rules around that. We are going to talk a little bit about some proposed overtime rules coming down the pike. So just for planning purposes, and then the fireworks. What summer ends without some fireworks? So Lori will talk about some NLRB updates. And then for our Daily Brew, we're going to talk about back to the office for real. Every Labor Day we hear, now we're going back to the office. So let's talk about who really is going back to the office and what you can expect and what you need to think about. And then with that, redefining company culture. So Lori, I'm going to turn it over to you for some piping hot topics.
All right. Well, we're going to start with some sort of, we tend to think of form stuff as tedious, but it's important. I will tell you that the federal government in August just every agency was like, here's information, here's something you need to know. So there's alerts coming out from various firms all over the place. We're going to start with the Department of Homeland Security and Form I-9, and then we'll talk a little bit about what's going on at the Department of Labor, and we'll spend the rest of the time on the National Labor Relations Board. For those of you who don't know, I just think this is sort of interesting, that Form I-9 was actually implemented back in 1986 under, I think it was Bush 1, under the Immigration Reform and Control Act. And it was designed to help strike a balance under immigration law with prohibiting discrimination against folks on the basis of national origin, but also putting the onus on employers to ensure that employees who were working in the United States were here with appropriate work authorization. So Form I-9 has been around for, that's a lot of math, that's almost 40 years. And every now and then it gets a new iteration, and we got a new iteration effective August 1st. This sort of coincides with, at the end, if you might remember, at the end of the spring, and I know I talked about this last time, the Department of Homeland Security had announced that employers had 30 days to reach I-9 compliance after those COVID-19 flexibilities ended. And there was a little bit of information about, how do we get in compliance again? Well, now we're going to get a flood of information. And this is one of the areas that the government likes to use for audit purposes. And so make sure that you are paying attention to how the new Form I-9 works. So a couple things that you need to know. Alison, let's just take a look at the form real quick, and then we'll come back to this slide. So this is the new form.
So I hope you can see this, but
yeah, it's not a big form. I mean, so part of what they did was to consolidate the form and to move sections together. So instead of being 2 sheets like it used to be, they've reduced sections 1 and 2 to a single sheet. And they've taken some of the other sections, like the re-verification section, and made it a supplement. If you need it, then you have it. But if you don't, then this is the appropriate form. This form must be used effective November 1st. Between now and then, you can still use the old form, which was dated October 19th, 2019. But after October 31st of 2023, you have to use this form for people going forward. You can switch back if you want, and we can talk about a couple of quick changes. This is not to say that you have to go and do an I-9 for everybody because you had people that you hired already. It's going forward for any employee hired after November 1st of 2023. Their I-9 must be completed on this new form. Similarly, if somebody leaves and comes back. So again, the changes are they consolidated to 1 page. They've created these standalone supplements. They've revised the list of acceptable documents to include some receipts. As you may recall, in the past, sometimes somebody wouldn't have the document, but they would show that they had applied for it. And it was a little bit confusing about when you could accept a receipt versus the document. Well, now the acceptable documents specifies which receipts can be included and which, as opposed to which you can't use. The instructions used to be 15 pages long. That's our efficiency at work. Now we're down to 8. But some of the stuff that's kind of cool, which is sort of interesting, I think, because of the change in the COVID restrictions, is we now have a fillable form. I-9 was one of the forms that was sort of like archaic. You still had to fill it out by hand and all of that. But now we have a fillable form that can be used. Coinciding with this, and this is only for E-Verify employers, and those are employers that use the government portal to do the verification. If you're a qualified employer and you are enrolled in E-Verify, then there are some new remote verification procedures. So if you'll recall, during COVID, there were these relaxed, sort of flexible verification procedures that applied solely because folks were working remotely. Those changed at the end of May. If you are an E-Verify employer, you can still use some remote verification procedures. And some of the keys under the regulations are pretty obvious, right? We have to examine and retain a clear and legible copy of any Form I-9 document. You must do a live interaction with the employee. So, but this counts as live. So if I were, in E-Verify and I was hiring Alison, I can have her complete the form with me, quote, with her, even though we're virtual. You have to create an E-Verify case if the employee is a new hire, and that's a specific process under the E-Verify system. And on the new Form I-9, there's actually a box that you would check that would say, this is the method that I used. So slowly but surely, the Department of Homeland Security is evolving and embracing technology. And if you want any more information on Form I-9 or thoughts on whether you want to do an audit or anything like that, it's actually not a bad time to go and check your Form I-9 compliance to see whether or not you've been doing it properly, and to make sure that you've taken care of any of those issues that might have occurred during the COVID remote period.
Okay.
All right. So Department of Labor, you all may recall that during the Obama administration, similarly, the Department of Labor tried to implement regulations where they were going to broaden the coverage of folks that are entitled to overtime. So the Fair Labor Standards Act has 4 key elements. One, that folks must be paid at least the federal minimum wage. Some states or local jurisdictions have minimum wages that are higher, but under the federal law, we're still at $7.25. It also requires that folks who work more than 40 hours in a work week are entitled to time and a half unless they fall into one of the specific exemptions. It has record-keeping requirements and it deals with child labor. But we're going to talk about the overtime. So one of my favorite expressions is salary does not always mean exempt. Sometimes employers think, oh, I'm going to put somebody on salary, therefore they're not entitled to overtime. Well, there is actually a whole set of criteria that people have to meet. And it's not the people, it's what the specific duties that they are performing. You've probably heard of the duties test. The 3 most well-known exemptions are the white-collar exemptions, the administrative exemption, the professional exemption. And then there are also an outside sales exemptions and some other exemptions that come into play. But ultimately, these regs that have been announced on August 30th, which you're going to see was a very hot day in the federal government. The idea is to move that threshold. So the first criteria in the exemption test is that people are paid on a salary basis at least a certain amount. Well, on August 30th, the Department of Labor said we should increase that amount to $1,059 per week. It's currently $684, so that's a significant increase. And or $55,068 per year. It's currently $35,568 a year. What this would mean would be that folks that make less than that would qualify for overtime, even if they are paid a salary and even if they meet the other duties test requirements. The Department of Labor believes that this extension of overtime protections will impact 3.6 million salaried workers. I will say that it's a little bit of let's see what happens, because as you may recall, during the Obama administration, we had a similar fire drill. Everybody was sort of freaking out. How do we move people? Should we play around with the way they're paid such that they won't actually be working 40 hours, and we'll shift them from exempt to not? It was like a whole thing. And then the regs were enjoined. And later, it was a different threshold that was implemented. So we're not quite sure yet. We're in the proposed rulemaking phase, so this isn't going to happen right away. There's a public comment period, and then a final rule will be published. And by then, you'll see whether or not there are going to be challenges. My guess is there will be an increase, but it will not be this significant. In the meantime, do not forget that certain states have their own overtime salary thresholds that might be different, such as California, Colorado, Maine, New York, and Washington. They already have higher thresholds. And so regardless of whether or not under federal law they might be exempt, if you're in one of those states, you have to see whether or not people might be entitled to overtime, even if not under the federal law.
Great. So from a timing perspective, I know we don't know precisely when it would happen. I know we do have some time. Any thoughts when they would make a decision? Would it be like first quarter 2024?
I think
or later.
Yeah, I don't think we'll know anything until mid-spring next year. Because what typically happens is the notice of proposed rulemaking will be 60 days, 90 days, 120 days, some time period. And then sometimes they will get a request to extend that time period. Mm-hmm. Then they will implement the final rule. At that point, you'll see a ton of press when this happens. It won't be quiet. Sure. And then if there are legal challenges, then that'll happen fairly quickly. So just sort of be thinking about the fact that some of your folks that are right around that salary level, if they're making maybe 40,000, 45,000, chances are pretty good that they will now be entitled to overtime unless you increase their salary. So, and that's a math question, right? What is the business? What makes more sense? It's a retention issue. And sometimes employees don't like to be entitled to overtime because they have a thing about, they want to be exempt and they think that that's better. And sometimes employees want the overtime. And so those are questions that Alison's team, can help you with in terms of the consultant piece. And I can certainly help you with the math and the legal compliance when we get to that point.
Yeah, one couple additional points there. When something like this happens, depending on where they land, it's a good time to step back and look at your pay structure. Just in general, just give it a review and make sure that it still meets the needs if you're going to be making these increases. And the second piece, Lori, that you addressed is, if we get to that point, when this happens, whatever the increase is, really be thoughtful about a communication strategy for those that would be affected, because there is this perception of someone being switched from exempt to non-exempt, that can just be an engagement issue if not addressed correctly. But again, both of us are available to help walk you through that. So, okay, let's get to the really interesting stuff here.
So, Alison, I know you attended, my partner and I did a webinar last week on one of these cases, the Cemex case, because it's kind of revolutionary in labor law. I want to say from the beginning, I know I would be portrayed by my union colleagues as being anti-union. I am not anti-union, but I do believe that employers need to recognize that having a unionized workforce is different. It has an impact on certain abilities as an employer. For example, and this is a big one, particularly for smaller or nonprofit organizations. If you have somebody call out, you might now have a supervisor kind of pinch hit and step in and say, okay, I'm going to do that while this person is out. It is not unusual under a union bargaining agreement to have prohibitions against supervisors doing, quote, bargaining unit work. So by way of example, that's the sort of thing that folks think, they don't necessarily think about when they get presented with this idea about maybe having a unionized workforce, people tend to think about it, well, it really has to do with wages or benefits. It doesn't. And in particular, in today's economy, a lot of organizing is really about workers wanting to have a voice and I'm quoting, a seat at the table. That's what you're seeing with Starbucks. That's what you saw a little bit with Amazon and a lot of the sort of well-publicized union organizing strategies. Younger workers in particular tend to skew more pro-union than older workers. But this is a different NLRB than we've seen in the past. You may remember during the Obama administration, we would talk about the pendulum. Historically, the National Labor Relations Act was passed to help establish a constant, or not constant's not the right word, but a stable labor policy with sort of rules that equalized employer and union relationships with employees and took away the violence that we saw at the turn of the century 100 years ago. And during the Obama administration, there were a lot of initiatives, regulations, and cases that came out that were sort of, quote, pro-union. And then the pendulum swang the other way during the Trump administration. Well, President Biden, one of his sort of key points was he wanted to be the most pro-labor administration in the history of the U.S. And his first action was to terminate the general counsel of the National Labor Relations Board and put in somebody who used to be the general counsel at the SEIU. This is not, I'm not politicizing this. This is just sort of the background for where we are. As a result of those changes and as a result of the administration's support of organizing, we have seen, I would say the pendulum is broken. I mean, these are really revolutionary changes. Historically, union representation is determined by a secret ballot election. So employees can decide by vote whether they want to be represented or not. While the second case I'm going to talk about, the Cemex case, almost stands that proposition on its head. So when I say this stuff is like hot and different, it's really groundbreaking. So the first case, which is really going to matter to every employer, is the Stericycle case. And you may recall that case, or not that case, that we had a similar issue during the Obama administration where handbooks were being scrutinized for all sorts of things, right? Your social media policy, your confidentiality provisions, lots of handbook reviews were going on at that point. And then we had a case called the Boeing case, which came down in 2017 and which everybody, I have to say, even on the union side, I think, breathed a little bit of, okay, these are specific sort of well-explained standards, right? And under that case, handbooks and company policies or workplace rules had 3 buckets. Category 1 rules were always lawful to maintain because the idea was that those rules wouldn't interfere with National Labor Relations Act rights or have any potential, or the fact that there was any potential adverse impact would be outweighed for the justification of those rules. Okay. Category 2 rules were the ones that warranted individual scrutiny because we have to kind of do this balancing and figure out whether the impact on protected rights outweighs any legitimate justifications. Category 3 rules were rules that were always unlawful to maintain because any legitimate justification would be outweighed by the chilling effect. And typically what we're talking about when we're talking about the chilling effect is Section 7 of the Act, which gives employees the right to engage in protected concerted activity. That is, to raise issues related to the workplace, safety, wages, scheduling, all of those things on behalf of themselves and other workers. That is protected, and you can't retaliate against an employee for engaging in those types of communications. The board now, and in particular, the current general counsel, Jennifer Abruzzo, strongly believe that protected concerted activity is paramount, that nothing should infringe on that, regardless really of any business justification. So I'll give you an example. In the past, employers had confidentiality policies in place, and those policies required employees to keep certain information protected. Like during a harassment investigation, you typically might tell a witness, do not discuss our interview or the aspects of this investigation with anyone else, because we want to maintain the integrity of the investigation. General Counsel Abruzzo's position is that that inherently interferes with that employee's Section 7 rights to be able to talk to others about workplace conditions, including whether or not there is a hostile workplace. So even though the EEOC's guidance says you should keep workplace investigations confidential, Jennifer Abruzzo has publicly stated, General Counsel Abruzzo has publicly stated that she does not see a conflict, that she doesn't see that as being a problem. Ultimately, Section 7 wins. So that's a lot of information, but here's what you need to know. Get your handbooks reviewed, because Stericycle now has done away with those 3 buckets and sort of the parameters that seem to help people go, oh, okay, I get it now. This case says that, and I should say the board's justification for the overruling of Boeing was, I'm going to read it to you, Boeing gave too little consideration to the chilling effect that work rules can have on workers' NLRA rights. So we're seeing this expansion of NLRA rights, and that's the theme here. In the now under Stericycle, the rule is going to be analyzed from the perspective of, and this is the phrase they're using, the economically dependent employee who contemplates engaging in Section 7 activity. So under the framework, a rule is now presumptively unlawful if it has, quote, a reasonable tendency to chill an employee's exercise of Section 7 rights. So a rule may be, this is the stuff that we're going, whoa, may be presumptively unlawful, even if a contrary, non-coercive interpretation of the rule is also reasonable. So it is a case-by-case basis. I will tell you there is, I guess, a chance that these cases will be appealed to the court system and maybe sent back, remanded, overturned. But right now, this is what we're dealing with. So I'm going to bet that everybody here who has a handbook has at least one rule that is now violative of the act, and that is going to matter because of the next case that I'm going to talk about. So the Cemex case is the one that really, it's just sort of killing me. So the Cemex case essentially says that if workers or a union come to an employer and say, we have majority support, the employees want us to represent them, that the employer now has 3 choices. Either say, okay, great, let's sit down and bargain, or the employer has to file what we call an RM petition with the National Labor Relations Board and ask for an election. Now, that's the big change. In the past, it was very typical that the union would file the petition and ask for the election. The third choice is to ignore them, and then you will get a charge, an unfair labor practice charge, alleging a failure to bargain in good faith, and you can defend that charge on the basis that you don't believe that the union has majority support. I'm not sure anybody's viewing that as the number one choice in our choice of strategies. Why am I saying that the Stericycle opinion has to do with Cemex? Because here's the wrinkle, or the bigger challenge really, is in the past, if you had an election, oftentimes the party that lost would file objections with the board, and they would say that certain conduct on the part of the employer, if it's the union filing the objections, or on the union, if the employer's filing the objections, resulted in a tainted isn't really the right word, but that the election results were coerced or influenced by this unfair labor practice. Well, the Cemex decision basically says that any unfair labor practice impacts a an election negatively, and the remedy that the board can implement is a bargaining order, meaning, you know what? We think, employer, that even your handbook that has this rule that we think is violative under Stericycle, that's an unfair labor practice charge. And we think that that is coercive enough that we're going to tell you that we're not even going to do the election over. Instead, you are required to sit down and bargain with the union on behalf of these employees. That's where we are. So this is, look, whether you're, kind of philosophically pro-union or anti-union, I think it's problematic that we have taken voting out of the equation, and that's what this has done. And it has created, Member Kaplan wrote in the dissent, he talked about this very issue, that a minor technical violation of a handbook rule could result in a bargaining order, and that seems disproportionate and unbalanced. I'm just going to mention briefly, American Federation for Children and Miller Plastic Products are two cases that deal with the expansion of who's covered by protected concerted activity. So in the past, protected concerted activity would have had to deal with protected, i.e. deal with terms and conditions of employment, things that we tend to think about as wages and safety and those sorts of things. Concerted means on behalf of myself and others. Well, under these decisions, number one, I can be engaged in protected concerted activity, even if I'm not speaking on behalf of my own employment relationship. If I am protesting or raising concerns about a third party's labor treatment, that can be covered as protected concerted activity now. And in the past, an individual's gripe didn't used to be covered. So if I just complained, I can't believe they make me work every Friday, that's terrible. Well, now, if I say, I can't believe they make us work every Friday, and people go, oh, you know what? She's right. My gripe is now protected concerted activity, even if I didn't necessarily intend for it to be so in the beginning. So we have this very strange case that we're going to have to look at, and this is what they're saying, the totality of circumstances after the activity, which is crazy, because the idea of protecting somebody from retaliation is that I did something that I sort of knew I was doing, that I had fear of being retaliated against. And now I could just do something that I didn't really, I'm just complaining, and it's really not about anything else. And now we have coverage. The last two decisions, the Went and the Techno decisions, I'm just mentioning, but they have to do with where you already have a union bargaining agreement in place, what happens at the expiration of that agreement. And there have been significant changes. I'm not going to spend any more time on them because I don't think we have any unionized folks here. But it impacts whether or not certain provisions will stay in place after the expiration of a collective bargaining agreement while you're in negotiations for a successor agreement and things like that. So this is, look at the dates of this: August 2nd, August 25th, August 31st, August 31st, August 30th, August 30th. We had a very, very, very hot summer in August at the National Labor Relations Board. So before I kind of turn things over to Alison, I absolutely want to tell you that you can't sort of ignore this or think it's not going to happen to you. I spent yesterday on the phone with a firm that has, they're sort of outside general counsel for nonprofits and smaller employers. And they have had 3 different employers in the past week get petitions either from an outside union or from workers who work there who are forming their own labor organization. So, hi, I'm Lori, and I want to be the ABC union at ABC Inc. And this is a petition by me and my coworkers, and we want to sit down with you and bargain over our employment. So you cannot ignore it. So review your handbook and your rules now. Again, work with Alison's team. I'm happy to do a legal review. If you have someone that you work with normally who does your employment law, make sure you give them a call. Make sure that they are an employment lawyer who has experience with the National Labor Relations Act, though, because it's a separate sort of area of expertise. And if they don't know it, they might miss something. Train your supervisors. Alison and I talk about this all the time. But not only now are we talking about training your supervisors to make them and make your employer an employer of choice or what have you, we are now doing it from a risk aversion standpoint, because whether you're unionized or not, if your employers engage in conduct that constitutes an unfair labor practice charge, individual employees have the right to file a charge with the National Labor Relations Board, and you will end up having to defend that charge the same way you defend an EEOC charge or other charges. And lastly, you might want to consider performing a vulnerability assessment and or educating your employees about what it means to be in a union. I am not saying that you have to get up there and union bash, but sometimes some unions lie and they say, hey, sign this card, we'll give you more information. But the card itself is actually an agreement to be represented. And because under the CEMEX case, the union can go to somebody and say, hey, you have 10 workers, 7 of them signed cards. That's majority support. We've taken away the election. Well, some of those workers who signed those cards may not have understood that that's what was going to happen. So in the past, a lot of employers said, we don't want to really get into this. Now you have to get into it, and you have to educate people upfront so that they know what they're doing. I think informed consent is fair for everybody and required. So
I just want to add
that is all the legal stuff.
You mentioned, and I don't remember the statistic you gave, but you mentioned that the newer generation in the workforce is more likely to be proponents of unionization, if I heard you correctly. And I just think when you think about training supervisors, and some of you may be in hybrid work environments or remote first work environments, you really have to be diligent to train, because you've got people newer to the workforce who may not have had exposure to these kinds of things. So just to be able to educate them and make them aware of what your organization offers and what to be aware of. But again, I was going to say, be careful in how you do it and seek guidance before you do it so that you don't unintentionally create some sort of potential issue for your organization.
Yeah, Gen Z and millennials have 65 and over 60% approval, pro-union approval ratings.
So, interesting.
Yeah.
Interesting. Well, that is a lot to digest, and I'm sure people are going to have questions. So again, Lori's contact info will be at the end of this. But do your due diligence as per her recommendations, and start reviewing your handbooks now, training those supervisors. We're going to transition into kind of what we're seeing on the HR front. And as I mentioned earlier, I feel like since COVID hit in 2020, every Labor Day, there has been a bit of a push or an effort to start to bring people back to the office. And this Labor Day was no different. We started hearing in the middle of the summer some of the actions that employers were taking. So we're going to talk a little bit about what the state of back to the office is, and for real, what organizations are doing and how they have to adjust their culture a bit or redefine their company culture to encourage people to want to come back to work. So you know, you may be in any one of these particular workplace structures, you know, an office first, a hybrid, or remote first. The data has suggested all along that the bulk of organizations are going to be in that hybrid space, and that's even projected out to 2028. If you look at some of the recent articles around like Harvard Business Review, they're saying hybrid's here to stay in some way, shape, or form. And you see this big group of large organizations with names that you would know that fall into that hybrid group, but they're all a little bit different. We are finding that many of them fall into that 2 or 3 days a week in the office, but some of them have more, some of them have less, and they have different varying degrees of flexibility in how they do it. You do have a couple that are office first, and they are in and they are coming down hard, and they are saying, you know, this is it, you've got to come back. And they're willing to bear the consequences of that. And then you have others that have just made the decision to be remote first. So let's see what the state of the union is here, which I think is kind of interesting. You know, it's no surprise that a large percentage of employers want staff back in the office for a variety of reasons that we'll speak about. But that number of employees that support coming back to the office still remains at about 20%. So that's that those aren't favorable statistics as an employer when you're trying to encourage people to come back. About 70%, 72% of companies have mandates regarding return to the office. I think you've heard, what was it, the CEO of, oh my goodness, I'm going to forget the name of the organization. Google came out with something that I'll share in a moment, but there was, Farmers Insurance came out with a big public announcement to all of its employees over video that they had to return to the office or else, and it really backfired for that CEO who had to come back and manage the situation a little bit differently. What studies show, and Castle Systems is an organization that's been monitoring this because they look at swipes in offices. They're still saying on average we're at 50% office occupancy, and this is across thousands of organizations. But by 2024, 90% of companies plan to return to the office in one way, shape, or form. I do think it's interesting that just under 50% of companies report that they lost more staff than anticipated when they started mandating that employees came back to the office. Again, that's going to potentially be one of the consequences, but people were not, according to this report, anticipating that it would be as high as they saw. And within that data, they were considering high loss of staff, meaning 3 or more critical roles in the organization that did not return. And then the other interesting statistic, and Lori, I think this is going to create some interesting dynamics in terms of access, et cetera, is that 41% of women are less likely to return to the office as opposed to 28% of men. And I'd be curious to kind of hear your thoughts on that, because that is a reality, right? If you don't have as much access or in-face time, that could potentially lead to some other gaps.
Yeah, I mean, I think the statistics bear out, and this probably isn't surprising, that older white men favor going back in the office more than any other demographic. And I know during the pandemic, we heard a lot about women dropping out of the workforce and the impact that would have. I think what you might see will be some litigation around maybe a disparate impact theory, or some plaintiff's lawyer is going to come up with something creative to say that, essentially this isn't necessary. Being in the office, quote, isn't necessary. And so it's an artificial construct that disproportionately impacts women, perhaps, other minorities as well. I don't know that's going to be a great exam question in my spring class. I'm going to tell you right now, because it's really not like a traditional theory that you kind of go, oh, okay, yeah, there's case law that supports that, but it's not crazy. So
yeah. When you think about promotions or you think about increases and things like that, that's where we'll have to keep an eye on it. As an employer, obviously, you want to keep an eye on it too, to make sure that you are creating opportunities and access for those who are hybrid or not working in the office if your organization permits that structure. So a couple of considerations and what we're hearing in terms of some of the best practices for organizations that are really in trying to enforce this return to work is being clear on the why. Why is it that you feel people need to come back to work? Because until that question is answered adequately, it's very tough to have people hear any other information that you're going to share. They'll say, well, we've been productive since COVID. We've been working this way. Why do we need to return to work now? And, statistically, the data supports that productivity shot up in 2020. It stayed up in 2021, dropped a little bit. 2022, it dropped a little bit, but in 2023, it's showing up that it's 3.7%, which is at its high, it was like 4.4% increase in productivity. So it's right back up there again. So you have to think about it. Is it the strategy and the needs? Is it learning and development opportunities? And I've heard this from a number of business leaders and HR professionals in certain industries that are saying, we do feel like we're missing opportunities for people to sit in on meetings ad hoc and listen and learn and grow. There's the creativity and innovation story. Now, you're starting to hear Apple is pulling people back. Facebook or Meta now is pulling people back because they're feeling that the face-to-face communication, which is really what it boils down to, they believe face-to-face communication inspires more creativity and innovation. I don't know. The jury's out on whether that's really the case, but
We
those
hear
are the
this at law
arguments.
firms. Yeah, we hear this at law firms too. Like, oh, well, the people aren't getting mentored and they're not, that accidental walking down the hall opportunity isn't happening there. I think that is old head thinking, as my daughters might have said when they were teens, right? That's because that's what me, myself included, that's what we're used to. But if you come from a perspective of intentionality and you come from a perspective of virtual interaction all the time, the newer workers, they are like, well, they don't see it the same way at all. They think, well, we can still be connected. You just have to be intentional in your mentoring as opposed to accidental.
And that's really key. So if you do have a meeting coming up and you have to be intentional about having that remote junior worker join that meeting virtually or whatever that happens to be. But really being clear on the why is important. You have to think about reload. So there are different varying plans on what organizations are doing. Some of them, and I know in our firm, we do a lot of work in the compensation space. And over the last 4 years, we've done quite a bit with geographical differentials and this and that. We have some organizations that are saying, you like Airbnb, they're going to be remote first and you can stay wherever you are and you will be paid the same as you would as if you worked at headquarters. That's one way of thinking. Others are saying, if you choose to stay where you are, then there will be pay differential. So you have to be clear on thinking through what your strategy is going to be with regards to relocation and with pay practices. Flexible models. It's not just being flexible 2-3 days a week. Some organizations are saying it has to be Tuesday, Wednesday, Thursday. Some are saying it's got to be 2-3 days. You figure out what those are going to be. Some are doing work weeks. There's a company in Ohio that has people all over the country, but for 1 week out of every month, they require that everybody be in the office for that week. And people have chosen to pay for their own hotel or space for that week. And it gives them the whole week together. They plan events, they do dinners, they really make it an experience that would make people want to be back in the office. So there's some really flexible models out there. I think you also have to think about workplace burnout, right? People have been accustomed to not having the hour commutes or 2-hour commutes or whatever they were, which added a long time to your work day. So think about how do you balance that and keep it reasonable so you don't increase levels of burnout. And then a big consideration that we're hearing about is experience parity. So if you are going to work in a hybrid environment, make sure that the experience for people, access to people, access to tools, access to resources is equal, that the people who are working in a hybrid environment have access to good technology and technology resources and tech support as the same as the people in the office would. Lots to think about there. Transparency is key. We always say this, in the absence of information, people make up their own. So as an organization, you can be in control of the messaging that you're sending out. And that's being clear on that why. Why are we doing that? Make sure your managers are aligned and clear on the why you are taking whatever workplace structure stance you are. If you're returning to work on a full capacity, 5-day a week, or even a hybrid capacity, be clear on the talking points that are the reason behind the return. A really big piece, and Lori, I'd love to hear your thoughts on this, is establishing guidelines or mandates to manage them. So for example, Google has added to their performance evaluations in office time. So that's the first that I've heard of that actually being part of a performance strategy. But their thinking is And we've seen it even in other big organizations where they've had mandates to come back to work, but people still aren't coming back to work. So how can you set reasonable guidelines and manage to them? Otherwise, how do your managers actually enforce the return to work? And Lori, I'd welcome your thoughts on that and what you're seeing. You're on mute, Lori.
I didn't want the puppies contributing to our conversation. So for those of you who don't know, I have 2 Siberian Huskies, and every now and then they have a contribution to make. So
they're not fans of anybody going back to work, right? They want
no, they're like, stay home. You can't leave us, Mom.
Yeah.
Anyway, it's not the first I've heard of this. Actually, there's several employers who, even if they don't say this is part of your what's that word, that hubris or whatever, part of your criteria, it's being commented on in their feedback or performance reviews. Look, I to some degree think this is going to be a capitalistic resolution, right? There will be people who want to work in the office, and there will be companies that want people to work in the office, and eventually they're probably going to find each other, because people who don't want to work in the office, who get dinged for not being in the office, are going to be like, I don't need this, and they're going to find a place to work where that's not what's valued. So I think this might shake out a little bit. I do think that the statistics right now bear out that that more employers are losing people because they are mandating return to work. I'd be curious what the data says about whether or not that mandate is explained, to your point, or not. I do think people are more inclined to re-engage if the justification makes sense to them, mm-hmm. as opposed to feeling arbitrary or patriarchal.
Yeah, and that leads us to our next bullet here about creating the employee experience strategy. If you're calling people back to work so that they can sit in an office to be on a Zoom call with other people when they could be doing that at home, that's probably not going to be an experience that is encouraging people to see value in increased collaboration that's different from what they could be doing in their own home. So really be thoughtful about the physical space. We've got people who are adding booking systems in, so you can book a space. They're hoteling, they're not having their own desks. You really have to think about what the physical space is going to be like, what the technology is going to be like, and again, what that communication is going to look like before you can encourage people to come back. And then be prepared for the expected and unexpected consequences. Not everybody is going to be on board, period. So you just have to plan for that. And it's not the end of the world. I think, Lori, that point is really well taken. Hey, people who really want to work remote first only are going to find and gravitate towards companies that are remote first only, and the others will find themselves. But you try to control what you can control and be prepared for unexpected. Were you going to say something? I'm sorry, I cut you off.
No. I was just going to say that you should be consistent. I know of firms and companies that say, we want people back in the office, and yet they're shrinking their footprint in their space. And so then they have hoteling arrangements or whatever, which is fine. But what that creates then, if somebody doesn't have a designated office and they say, fine, I'll come in, and then they can't get a space because there's no room in the hotel spaces, then they stay home, then they get dinged for staying home. It's like,
right. That's where having some guidelines and something to manage to be as clear as possible. And please, you've probably heard us say this before, it's all about communicating what these expectations are. You can't just send out one email or share it on one call and think that people are going to retain that. You have to have it in multiple different places, multiple different ways, so that people can be reminded of what the guidelines are and that you give managers something to manage to. Otherwise, you create this sense of unfairness potentially in the workplace, which could lead to all the things Lori spoke about before. So just to kind of wrap up our conversation today, some tips for you. Really think about the employee experience strategy if you're returning to work, or you're trying to get people, you have returned to work or returned to the office, but it's not going quite the way you thought it would. Define the why, what, when, how, who, etc. build in that communication plan, and make sure your managers are comfortable and confident speaking to it, well aligned. Make sure it includes some sort of regular check-in process, whether that's one-on-one, surveys, department check-ins, focus groups, you name it, whatever works for your organization. But you can't just set it and forget it. You have to check in regularly to see how it is working for people. We're in the world of remaining flexible, flexibility and consistency. I know that sounds a little bit ironic, but you can be consistent with flexibility if you have those guidelines set in place. There are always one-off situations, so just remain some flexible. And training managers on how to lead in this environment, it isn't easy, and it requires different skill sets, and it requires different approaches. So make sure you're bringing to them the latest and greatest on tips and tools and techniques to lead effectively. And then, as Lori spoke about, with regards to all the changes in the NLRB, review your handbook rules now, and make sure your supervisors know about unfair labor practices and what organizing can look like, especially if not everybody's in the office. It might look a little bit different. And performing a vulnerability assessment, educate your employees. What else, Lori? What have we forgotten?
I mean, I feel like we could talk for hours. I just am so appreciative that these folks wanted to spend the morning with us. And again, I really urge you to reach out if you have somebody that you partner with, or you need somebody to partner with, contact Alison or me, and we can make sure you're with the right person. But it's really important to take a few moments and do that assessment of your organization. Make sure that people are engaged, that your policies and procedures are up to date, that your supervisors have been trained effectively. It's worth doing that little bit of work now for the headache and cost it will save you later.
Great. And we did have a couple questions that had been asked about state-specific salary exemption rates. For the person who asked about New York, it's a more complicated answer because they have different rates for different parts of New York City, New York State, Long Island. So if you want to reach out to me separately via email, our contact information is here. I'm happy to share that information with you. But on behalf of Lori and myself and Fox Rothschild and Exude Human Capital, we just want to thank you for taking time to spend with us this morning. And we hope that there are a couple of tidbits that you can take back to your workplaces that you find helpful today. And we hope to see you on the next Morning Blend. Thank you so much.
Thank you. Have a great week.